Um, so I am talking to you today about sexual assault. And when I thought about what topic I wanted to talk about, this was when the Epstein files were actually being talked about. And now that we seem to have moved on from the Epstein files, as we are wont to do when topics of sexual assault come up in the public space, we sort of move on rather quickly. Um, it's sort of hard to keep track of all the things. And yet, right? And yet, there is always another crisis. There's always something else to focus on. And we do have a difficult time in our society, in particular, in taking sexual assault and sexual violence seriously. Um, and so, despite all the things that are happening in the world, all the awful, horrible, violent things that are happening in the world, I do want to just take a moment right now to bring our attention back to the topic of sexual assault. And in particular, to talk about how our legal and political systems are not only set up not to address the problem of sexual assault, but in fact, actually to villainize people who are survivors of sexual assault, who experience sexual violence. So I've written quite a bit. I teach quite a bit about sexual assault. I also teach a lot about the legal system in the US. And, I've come to realize that there's a lot of different ways in which our legal system in particular is set up in ways that fail um, survivors of sexual assault. And so I want to talk about today the ways in which these processes do fail survivors, the way in which these processes vilify survivors, and the ways in which more recently our social and political spaces have become toxic spaces for folks who are making claims of sexual assault, for folks who are seeking healing, for people who want to tell their stories, for people who want to engage in consciousness raising. Um, and I argue that part of the reason why we've had this sort of increase in toxicity in our social and political spaces is in particular because of the sorts of processes that we find in the legal setting. So in a way, there's spillover, right? There's the bleeding of the sort of legal concepts and legal processes into our public and social spaces. Um, so to get started, let's just talk about what legal processes look like. What does it mean when we talk about um, the legal processes that in particular, are relevant in the context of criminal law? And so the first thing we think about when we think about a legal process in the context of a crime is due process, right? Due process is sort of the hallmark of our justice system, right? We like due process. We want to make sure that we have access to the sort of cornerstones of due process, which is a fair trial, which is the capacity to confront your accuser, and which, of course, is the very important presumption of innocence. These are all things that are really critical for to have a criminal justice system, to have a criminal process um, that is objectively evaluating whether or not a claim of a crime or evidence of a crime is in fact persuasive, and to make sure that there aren't other reasons why a person might be there, to make sure that somebody hasn't been wrongly accused, to make sure that a crime, in fact, has been committed. And so, of course, one of the hallmarks of due process is this idea of reasonable doubt. So, what does that mean? It means that if someone's been accused of a crime, you need to be able to prove that they did it beyond a reasonable doubt, right? So, if right, it can't just be that there might be some evidence. It can't just be that there might be circumstantial evidence. It can't just be that you've pointed a finger at someone and said you've committed the crime. It has to be that it's beyond a reasonable doubt that that the evidence is persuasive, right? And so, of course, right, it rests on a certain kind of evidence. It rests on objective evidence. It rests on sometimes third-party evidence, right? So there are all sorts of evidence that are paramount to proving that somebody is accused, has committed a crime beyond a shadow of a doubt, beyond reasonable doubt. Um, and so this also creates what's called a burden of proof, right? A burden of proof. Burden of proof exists in all sorts of cases. It exists in civil cases, it exists in criminal cases, but in criminal cases, the burden of proof is on the person who is accusing somebody of a crime. In other words, that idea of a presumption of innocence that's part of due process requires that a person that the person that has the burden to prove that someone has committed the crime is the person that is doing the accusing. In other words, the prosecutor in this particular instance, right? So if the presumption is that somebody who's been accused is innocent, they don't have to prove that they're not guilty. The other person has to prove that somebody has committed the crime. So, what does this all mean? What does this all mean in the context of rape and sexual assault? In a typical crime, an accuser of a crime, somebody, right, the prosecutor, is accusing somebody of being present when a crime is committed, but there isn't really any doubt that a crime has been committed. So, for instance, if somebody robs a liquor store, and you're trying to figure out who robbed the liquor store, you're not going to argue that the liquor store wasn't robbed. You probably have incontrovertible evidence that, in fact, somebody robbed a liquor store, and you're just trying to figure out who exactly it was who committed the crime. When you're talking about the accuser of sexual assault, they're trying to prove something very different, right? They're trying to prove that a crime actually occurred, right? So let's think about what the evidence is when we're talking about a typical crime. We're talking about witnesses, right? We're talking about DNA or fingerprints. We're talking about video, right? We're talking about any kind of evidence that can show incontrovertible proof that somebody was there at the time that a crime was committed. We're all in agreement that a crime was committed. We're trying to show that this person in particular committed the crime. When we are in the context of a rape or sexual assault case, we're using the same evidence. We're requiring witnesses. We're requiring DNA or fingerprints or some other proof that, right, that person's body was present during the committing of the crime. We may even want to have some evidence of a video or some other thing happening in order to prove that this person was there. But it's not sufficient to demonstrate that somebody was there because, of course, they can just argue that they were there having consensual sex. So the burden of proof when somebody is accusing somebody of sexual assault isn't on proving that somebody was there. It's proving that in fact a crime occurred, right? And this is where things get really problematic. And they get problematic in part because of this norm, right? This norm, it's not a process, but it's a norm of privacy, right? We have a tendency, in particular in the legal system, to essentially require that crimes have sort of a public nature to it, right? We want to have third-party witnesses be able to verify that something occurred. Take the murders of Renee Good and Alex Preddy, right? We have, untold numbers of video witness accounts that have been dissected, that have been viewed and reviewed and, compared to each other in order to create a timeline of what happened, right? Such that now there's incontrovertible evidence that these two individuals were murdered, and now we are moving forward with the case, right? Our legal system, in a way, requires, right, witnesses to something happening. But rape trials, sexual assault, rape, sexual violence has a tendency to happen in private, right? So that even if you have witnesses to two people being together, to even to two people engaging in some forms of sexual intimacy, a lot of times those particular interactions are explained away by the person who's been accused of rape as consensual, right? Very rarely is somebody going to actually witness the entirety of an assault from start to finish. Very rarely is someone going to be able to witness that, in fact, an act of sexual intimacy is, in fact, a violent act, right? And not a consensual act. And so it's very, very hard. It's very difficult in the system that we have, right? With the legal hurdles that we have, with the requirements of proof, with the requirements of being able to prove beyond a reasonable doubt. It's very hard for somebody who is accusing somebody of sexual assault that, in fact, a sexual assault did occur, even if they were present, even if there's DNA, even if there's other bodily fluids, right? Even if there are people witnessing, right, interactions of a sexual nature between two people. It is very hard for somebody who is accusing somebody of sexual assault to be able to prove beyond a reasonable doubt that those interactions were violent as opposed to consensual. And this is especially true, right? This is especially true when we're talking about sexual assault and sexual violence, where the sexual act itself is the violent act, right? So oftentimes, right, it'll be the case that if somebody is brutalized in the midst of an attack, if they have experienced physical trauma apart from the act, the violent act of sex, they have an easier time of being able to prove that, in fact, the sex act was not consensual because they have the marking, the telltale markings of an assault, a physical assault, right? They've been punched, they've been beaten, they've been scratched, they have other forms of physical trauma, right? But what happens in the lion's share of physical assault or sexual assaults, where we don't have those typical markings, where we don't have those telltale signs of physical violence, where the violence is in fact the sexual act, it becomes an instance of he said, she said, right? Where the accused is arguing that it was consensual, and the accuser is arguing, stating that the sex act was the violent act in and of itself. And so this becomes deeply problematic in part, right? Because this has an impact on survivors, not just in the incidence of the losses that they experience as a function of bringing cases to court, but it also makes the legal space a violent space for folks who have experienced sexual assault, right? And this is part of the reason why something like 95% of people who have experienced sexual assault or sexual violence don't use the legal system, right? Do not report the crimes that have happened to them, because it just simply isn't a safe space for people to bring in their experiences. And part of the reason is A, because it is very, very difficult to make, right, to bring the crime of sexual assault to light in the context of the constraints placed as a function of the legal system, as a function of due process. But it is also because when you lose a case as a survivor of sexual assault, it means something different than when you lose a case as a survivor of some other sort of crime. And so, what do I mean by that? What I mean is that, right, and this goes back to the sort of what are you trying to prove, right, when you bring a criminal case into a courtroom. Right, a typical criminal case, again, you're trying to prove that this person committed a crime that everyone agrees happened. If you lose a case involving sexual assault, if you have accused somebody of sexual assault and they have prevailed in court, you are being accused essentially, right? The default is that you have lied, right? The default is that you can't be believed. The default is that the sex act was not a criminal act, was not a violent act, but was in fact and should be perceived as a consensual act, right? So unlike other situations where the victim of a crime has brought their case to court, right, that victim of that crime doesn't walk out feeling as if they've been told the crime didn't occur. They're going to walk out feeling like people didn't listen to them and they don't believe them, that the person that they believe committed the crime. But, right, the crime did occur, right? And there is consensus about that fact. But when you have a survivor of sexual assault bringing a case to court and they do not prevail, they are essentially being told that you are wrong, that the violent act that you experienced, right, the sex act that you experienced as violence, the rape that you experienced, the assault that you experienced wasn't rape, wasn't an assault, was in fact consensual, right? So the trauma that heaps onto an individual who's already been traumatized and violated by the violent sex act that they've experienced, right, was now doubled, right? Because in addition to having experienced this violent sexual act, right, the most violative of sexual acts, they're now being told that what they experienced didn't occur, right? And so it adds on to the kinds of trauma that survivors of sexual assault experience, where they, right, they experience profound distrust of intimacy. But now they're going to experience profound distrust of themselves, of their own perceptions, of the capacity to distinguish between intimate, positive, nurturing sexual acts, intimate acts, and violent, aggressive, non-consensual acts, right? The capacity to be able to distinguish what looks like the same act, but in fact is should be distinguished in very different ways. So this has profound consequences for survivors of sexual assault. And and for some people, that's a sacrifice they're willing to make, right? For some people, they can say, okay, the legal system isn't for me, but I don't need to worry about the legal system because I'm not going to use the legal system. I'm not going to bring my case to court. I am 95% of people who have experienced sexual assault. I'm just going to stay out of court and I'm going to know that I'm going to have my day. I'm going to be able to speak my truth in the myriad other spaces that have been created, whether it's consciousness raising, whether it's me telling my story, whether it's me um, self-reporting a sexual assault, in an interview or on a survey, whether it's me, speaking up, right, and speaking out on campus or in a variety of different spaces where we create spaces of healing for individuals who've experienced sexual assault. But, and this is where things have gotten really dreadful. Um, the fact is that the legal processes, right? Again, the prongs of due process, reasonable doubt, burden of proof, right, and the sort of relegation of any form of intimate crime to the private realm, right? This idea that it's between two people and that we shouldn't get involved and that we can never really know the truth of something because it happens in the context of an intimate space, those those trappings of formal legal contestation have now been brought into non-legal spaces, right? In particular, into our social and political spaces, such that now it is the case that when people engage in, forms of consciousness raising, whether that is coming forward um, to call out the bad acts of a Supreme Court justice, whether that is to call out the bad acts of a sitting president, whether that is to call out the bad acts of an actor or a Hollywood producer, whether that is engaging in consciousness raising, going on campus and talking about your experience of sexual assault or sexual violence. Whether that is self-reporting in social media, right? During the Me Too movement, we had record levels of individuals reporting, right, on Twitter back when it was Twitter, on Facebook, on Instagram, in other spaces, their experiences of sexual assault and sexual violence. And even reporting in the context of surveys, right? Anonymous surveys. Now it is the case that even in those spaces, right, where there are no legal burdens to be met, where a particular person isn't being accused of a thing and thus stands the risk of being sent to prison for that accusation, right, where there is very little risk to the individual who is um, being accused, or where there isn't a specific individual being accused, the same questioning, right, the same requirements of proof, right? The same standards of what it means to be legally raped, the same skepticism that we encounter in a courtroom is now being brought to bear outside of a courtroom, right? So when individuals come forward to testify about their experiences with, various individuals who've been accused of rape or sexual violence, right? They are questioned in much the same way that they are questioned in a court of law. And maybe that's okay, right? Maybe we should expect that the same formalities of law should come up when we are accusing a specific person. Maybe it's okay that the kinds of questioning that we did um, to Anita Hill, to the accusers of Justice Kavanaugh when he was accused of sexual violence. Maybe that's okay because maybe we should be able to expect individuals to have the same expectations of reasonable doubt and due process, even outside of a courtroom. But what about consciousness raising? What about um, when an individual speaks their experience about sexual violence and doesn't name an individual, simply says that they experienced sexual violence in the context of a date, in the context of a frat party, when they were walking down the street. Even in these spaces where there isn't a person being accused, we still feel comfortable and we frequently will question whether or not that quote unquote counts as rape, right? I think we've all heard, right? People say things like, does that count as rape? And so we feel comfortable, right? We feel comfortable, we feel emboldened because of these legal processes, right, because our knee-jerk assumption um, is that an individual accused of rape, or even an abstract, unnamed person that has been accused of rape, is innocent until proven guilty, which means, of course, that a person accusing somebody of rape, or a person experiencing rape and speaking their truth, is, of course, lying until proven that they are, in fact, telling the truth, that they did, in fact, experience sexual violence. Um, and so, even in these consciousness raising spaces, right, even when we are participate in speak outs, even when we, um, go to social media and report our experiences, we are questioned, right? We are subjected to inquiry and skepticism about the veracity of our claims, and about whether the metrics, right, whether we are experiencing violence at the level of a sexual assault or at the level of a rape. Right? The distinguishing comments are always, maybe this is just regret. Maybe this was just, um, an unsatisfactory sexual act, but does it really count as rape? Does it really count as sexual assault? Does it really count as sexual violence? And we even see this, right, in the context of self-reporting on surveys. So we have, during the Obama administration, um, he spent a lot of time trying to figure out ways to contend with rising rates of sexual assault and sexual violence on campus, right? And so he wrote what are called Dear Colleagues letters, right? And a Dear Colleague letter is basically a letter sent from the executive agency to the various institutions that are governed by that agency to say that these are the way that the regs have changed. And so in one Dear Colleagues letter, he referenced data points. He referenced surveys that were commissioned by the CDC, that were commissioned by other agencies, to identify the rates of sexual assault and sexual violence, in particular on campus. And when those reports were issued, when the CDC issued its report, and found that 1 in 4 women were sexually assaulted on campus, um, instead of us coming together as a society to identify the ingredients, right, to identify the conditions that lead to 1 in 4 women reporting sexual violence on campus, instead of us coming together to figure out how we can rein in this epidemic of violence that young women experience, we actually quibbled with the survey, right? We quibbled with the questions that the survey asked. We quibbled with the choices that people were given in order to identify their own experience. We quibbled with the coding of whether a particular choice that somebody identified as adequately reflecting the experiences they had should have been coded as sexual violence, should have been coded as sexual assault, or should have been coded as something else. And we spent lots of time debating this, right? Lots of mainstream newspapers, New York Times, Washington Post, right? All sorts of editorials, opinion pieces, analyses, that were put forth by scholars, by researchers, by all sorts of people, contesting the veracity of the claims being made as a function of a survey instrument, right? And so instead of coming together, it created, right, a rift. It created conflict, because people responded with incredulity and skepticism instead of believing people who self-report on a survey, and believing that, in fact, the experiences that people were reporting were, in fact, experiences of sexual violence. Which then, of course, leads us to the statistics, right? And so now, right now, the statistic is actually 1 in 3 women will experience sexual violence on campus, and that 1 in 2 um, women will experience some form of unwanted sexual activity or sexual assault in their lifetime, right? So the reported rates have increased, um, and still, right, and still. We are engaging in mind-numbing debates about, again, the legitimacy of those statistics, right? Whether those statistics actually mean anything. And so, what does this mean in terms of politicization? What it means is that right, we could live in a world where we just don't talk about sexual assault, right? Maybe it is the case that the sort of pervasiveness of legal doubt into extra legal spaces has meant that we just don't have conversations about sexual assault because we don't believe it happens, and we question anybody who raises it as a thing that happens. And so our discussions of sexual assault and sexual violence only happen in private, right? That would be one version of the world. That would be one version of an outcome that ensues as a function of these sorts of legal skepticisms um, seeping into our social spaces. But that's not the world we live in, right? We do talk about sexual assault. We do talk about sexual violence. We just don't talk about it for the sake of survivors. We talk about it for the sake of serving some other purpose, right? So we paid attention to the survivors of Kavanaugh's sexual assault, not because we were bringing justice to the survivors of Kavanaugh's sexual assaults or sexual abuses, right? The statute of limitations in some ways had run out on stuff he did. And a lot of those women were not bringing any claims forward of a criminal nature. They were just attempting to demonstrate the kind of human that he was. Um, and so the focus on sexual assault and sexual violence in the context of the Kavanaugh hearings was not about sexual assault or sexual violence or about those women. It was about knocking down a plausible political adversary, right? Same thing with the Anita Hill hearings, right? The Anita Hill hearings were not about centering Anita Hill and centering Anita Hill's experiences. They were about bringing down Clarence Thomas, right? And in fact, um, largely because, right, these hearings were situated around Thomas, Anita Hill was disparaged, right? Former President Biden only recently apologized to Anita Hill, and really, only minimally for the role he played in disparaging and downgrading and downplaying her experiences and her her recitation of her truth of the experiences of her experiences under Thomas. Right. So these instances of fixating and focusing on the victims and survivors of sexual violence are meant to serve some other purpose that's not about, right, survivors of sexual violence. That is usually about bringing somebody down, bringing some official down. Um, right. We see this in the Epstein files, right? We see, folks on the left slathering, excitedly about the possibility that in these horrible, awful accounts of sexual violence against young women, against young girls, that we might be able to catch, right? We might be able to get that gotcha moment where we can bring down our political adversary. We can bring down Donald Trump. We can bring down his cronies. We could bring down other people that we might not like. And so again, the focus is not on these girls, right? The focus is not on the horrible, awful experiences that they had, right? It's not even on the system of recruitment, right? Or the systems of sexual slavery, right? That are sort of that give rise to the conditions for Epstein and his friends to be able to commit these acts of violence. It's not about any of those things. It's literally just about, right, combing through the Epstein files to see if we can find a way to bring down a president that we don't like, right? Or a way to bring down other folks that we think we might not like. Um, there's also other ways in which sexual assault is politicized. So, bathroom panic, right? So, bathroom panic is what we call the panic that folks in conservative spaces created as a function of um, queer and trans advocates arguing for gender affirming restrooms, right? Gender affirming spaces for gender nonconforming and transgender individuals to be able to use the bathroom. And so this sort of started In the mid 2000s, you had a rise in the number of laws that were outlawing discrimination on the basis of gender identity. And so a part of the response to that was to suggest that now, quote unquote, men would be using women's bathrooms. And of course, in the context of that space, they argued that women would be more likely to be sexually assaulted in bathrooms because men would be using women's bathrooms, right? So the sort of central feature of bathroom panic was a concern about sexual assault, and in particular, a concern about sexual assault against women in the context of bathrooms, right? Um, People who were expressing bathroom panic, people who were taking to the streets to argue that transgender people shouldn't be able to use bathrooms that match their gender identity, people who were arguing that young girls were going to be um, victimized in the most private of spaces. These are right, these are not people who were centering sexual assault in the spaces where they actually occur, right? In fact, these are the same people, the same legislators, the same politicians, the same party hacks, who were actually arguing for stronger due process provisions in the context of responses to sexual assault on campus, right? These were the same people who were making it far more difficult for young women who are experiencing sexual violence, for everyone experiencing sexual violence on campus, to be able to make claims against the folks who had committed the crimes. Right? These are folks who time and time again downplay the importance, downplay the prevalence, downplay the trauma of sexual violence, except when it serves a particular purpose. And so, in the context of bathroom panic, in the context of targeting transgender women in particular, they brought out, right? They brought out the very symbolic issue of sexual violence against women, right? They trotted it out to center it in that space, but not at all for the survivors of sexual violence, merely to target transgender individuals. And to use it as part of the slate of hate against LGBTQ folks, right? And it was very successful, right? It was very successful, and in fact, it's what spearheaded then the sort of central claims around transgender athletes, and in particular trans female athletes, was again this sort of concern about women, right? And then, of course, there was the so-called rape election, right? I'm not sure if people caught that when Trump was first running against Hillary Clinton, people were calling this the rape election, right? People were calling this a rape election because, right, there was the obvious focus on Trump as a sexual predator, right? The whole sort of grab him by the pussy comment was something that, ruffled a lot of feathers, understandably. And so the hope, right, among folks on the liberal spectrum was that people wouldn't stand for this, right? That people would see that this person is a sexual predator, and thus we could finally, this he would meet his downfall, but B, we could finally sort of make this about sexual assault and rape, that we could finally bring to light the problem of sexual assault and sexual violence. But of course, that didn't happen, right? That didn't happen at all, right? Instead of being held accountable for the sorts of, for his descriptions of women, for the many accusers of rape that he encountered throughout that first election, right? Instead, right, he berated women who had accused him of rape, called them unattractive, or accused them of being promiscuous, right, and thus unable to have experienced rape because of their promiscuity. Right. And then in fact, right, then, right, the tables were switched, right? And so in an attempt to ruffle Hillary Clinton, right, then candidate Trump brought two women who had accused then President Clinton or former President Clinton of sexual assault, brought them on stage, right, brought them as guests to the debate, in a way of ruffling Hillary Clinton and calling attention to Bill Clinton's proclivities, Bill Clinton's past associations with sexual assault, right? In neither of those cases was this about actual sexual assault. In neither of those cases was this about, right, the people who had experienced the assault, the survivors of the assault. It was simply about one-upsmanship, right? It was simply another version of a political gotcha, right? Another way to ruffle feathers, right? And so the only ways in which sexual assault was featured, um, right, in the so-called rape election, wasn't about sexual assault at all, right? It was just about finding dirt, right? It was just about finding ways of bringing down our adversaries and finding ways of calling attention, right, to the problems of potential candidates, right? So these are all situations where we've trotted out, where we've pretended that we care about sexual assault, but really for other purposes, right? And we even are seeing this in the Epstein files, right? We even are seeing this in the context of Epstein hearings, right? In addition to people, um, you know, combing through these horrible accounts of sexual assault to find Trump, to find, right, their other political adversaries, they are also trying to figure out ways of excusing the presence of people that they like, right? So on social media, when Noam Chomsky, right, pictures of Noam Chomsky emerged in the Epstein files, um, lefties are bending over backwards to excuse why he was there, right? To suggest that he was there, but it wasn't about sexual assault, or he was there, but he didn't know what Epstein did, or he was there, but it's not the same thing, right? Excuse, 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 right? Proving once again, right, that there's always an asterisk next to sexual assault, right? There's always an asterisk next to discussions of rape and sexual violence, right? And that asterisk is if it's right, if the accusation is being made against somebody that I like, it's not rape or sexual violence. Or if I want to actually talk meaningfully about sexual assault and sexual violence, if I want to center with the survivors, it's a wait, wait until we get to you. Right now we need to bring down Trump. Right now we need to bring down this. Right now we need to talk about this. We'll talk about your issues later, right? And so, what does all this mean? Is this just an unloading of bad news? And I've certainly been accused in my writings and in my teachings as just unloading bad news. And it is all bad news. It's not good. But it does mean, and I think this is true of so much of what we're experiencing now, that our institutions are failing us, right? That legal institutions have been failing um, survivors of sexual assault from the get-go, right? It's never been an institution that um, could hold the truths of sexual violence, could account for the experiences and the realities and the context of sexual violence, and then bring justice, right, for survivors of sexual violence and against the folks who have been accused of that violence, right? The legal system has never been that space. It's never been created for that space. Um, right? It used to be the case that we could, right, that we could create public spaces outside of that realm. It used to be the case that we could engage in public consciousness raising and not have to account for those legal constraints, right? But now that sort of dial has been moved, right? And now we are in a moment of like extraordinary and duplicitous, really, politicization of sexual assault, right? The deploying of it for other purposes, even at the same time that we downgrade the survivors of sexual violence and their accounts. And so we have to take matters into our own hands, right? We have to account for this reality when we are dealing with the truth of sexual violence. Right. I'm a survivor of sexual violence. I suspect that there are others on this call who are survivors of sexual violence. And so many people in our lives are as well. The statistics bear that out as truth. And we have to do better at recognizing the failures of these institutions in order to create the spaces ourselves through mutual aid, through a scaffolding of community, um, you know, by, making sure that we have spaces where people can heal, where people can be in community, where people can tell their truths and tell their stories, and where we can engage in forms of prevention. Even on campus, right, the whole space has become increasingly legalized, right? Such that as a professor, I'm a mandatory reporter, and so I used to be a safe space for my students, in particular my female students, to come and report their experiences of sexual violence. not because they wanted to report it, because they didn't, because they understood the limitations of the legal setting, um, but because they wanted to talk, because they wanted to process, because they wanted to cry, because they wanted to rage, because they wanted to tell their story and have somebody who understood where they were coming from reflect back to them um, an equal amount of rage, compassion, empathy, sadness, and empowerment. But now, as a mandatory reporter, because those spaces have become heavily legalized, I'm not at liberty to be an open space for my students to come to me because I have to immediately report their experiences to my Title IX office, which immediately puts them in the crosshairs of the legal system, right? In the crosshairs of a legal system that ultimately, 9 times out of 10, will doubt their credibility and call them a liar. And so we need to be better. We need to do better. We need to be attendant to the realities of the situation that we face. We need to be attendant to the realities um, that that women are right, that people are being questioned, that survivors of sexual assault, men and women, cis and trans, are going to have their credibility demolished, and we need to create spaces where that doesn't happen. So I will stop there, and I am open to questions or discussion.